Hey viewers, by all standards, I want to submit that African customary law and the quest for customary law by Africans and non-Africans is more than ever before very, very vigorous and quite wanting when it comes to seeing how African customary law may make contribution to the societal issues and questions of justice today. Is the informal law or informal justice that is not properly, appropriately documented be the response to our human problems today? Well, the answer is yes. African customary law, by its nature and standards, entails and manifests a huge amount of values and principles that still the humanity worldwide can rely on in order to respond appropriately to certain challenges. They may be challenges of armed conflicts, they may be economic challenges, they may be racial challenges, challenges pertaining to distributive justice, equality and inequality, iniquity, problems of racial hatred, hate speech. Well, all these are real problems in our situations today. The reason being, African states, modern states, have got pluralism when it comes to the social setups, ethnic groups, racial groups, different cultural groups, different beliefs, different religions. Well, having this cosmopolitan project and idea of the universalism brings African customary law in more advanced question of how it can coexist alongside the borrowed legal systems in the independent African states. Such questions of the restatement and documentation of customary law and informal justice system would provide some solution and lasting trajectories for both African states and non-African states at the same level. This is again the question of this interconnectedness of our world today. We trade together, we do business together, people migrate, people live in other countries and they want to live there in their own rights. Well, in such kind of metropolitan cities as in the United States of America, in many European countries, and also in some Asiatic countries, that intermingling of populations is creating another scenario in which lawmakers as well as policymakers are looking for a wider understanding, a wider knowledge when it comes to African customary law, its values, its principles, what it entails, but also its doctrines. Well, this is not what some people think, that African law is no law. African law is like a dead law. It is instead a living law. It is a living law because many people today who have got African background, they live in the dichotomy of law. That means they are there to the constitution and the legislation or the statutory law at the same time. The judicial services, judicial systems are also dealing with matters involving both statutory law and customary law at the same time. Well, it is not just a wishful statement to say that African customary law as a project has come to an age in which many readers, our young people, look at what is there for the Africans to explain and fit well in the modern society today and the future. There is need for going back to the indigenous knowledge in order to grapple with challenges imposed upon the humans by our environment, our changing ecosystems, the climate change, changing mentality, and very many other problems that human beings are faced with today. It is no longer a question of thinking in terms of foreign ideas, foreign laws, or other laws like international law to explain to us how we live in our social setups, both in Africa and outside Africa. Well, it is a contribution that we have seen from Justice Elias Taslim Olawale, a Nigerian, in 1956, the nature of African customary law. We have seen this again repeated by Justice Eugene Cochran, a Briton, that left us literature when it comes to the case law in African customary law. The restatement, one on marriage, the other one on African divorce. These collections should not die out in the past history, but even in the 21st century, there is need to come up with progressive research and also debates on how African customary law be of help when it comes to how we respond to our human challenges in the society today. This is a question of time and space. It is today. It is about tomorrow. It is not about the past. Let's not look at African customary law, then try to group it in what I would call the museums of the past. It should be a real understanding of the type of law that binds upon many, many members of the human society today. How many people still respect and follow their African customary law, its principles in all dimensions, by extension also its own institutions like customary courts, like the institution of elders, the council of elders, institution of marriage, institutions such as family, succession, how people hold property. It is still something that we should not wish away. Well, these are apologetic kind of statements, but what we need to address here, and I feel privileged to talk about it, is how to develop an African jurisprudence. This is a clear way of uplifting and upscaling the African customary law project from where it was left to where it should take off and bring up new notions and concepts about how the law should be designed in a manner that would fit well with the required natural justice, with the required all types of justice, retributive justice, distributive justice, as well as correctional justice. Well, this is the question of research, and there is so much and a huge area of research that has got so much to learn from the Africans, from the residual law, those elements that still the very African people still cherish and uphold to. There is African justice system. There is African understanding of how humans relate in the space that is the planet Earth. How Africans relate to nature, for instance, but also how Africans relate to one another, how they associate, how they understand and interpret such concepts as rights and obligations, how they look at the judicial system, how they put all this into the concept of wisdom. This is going again to be seen in many other topics addressed under the thematic area, and collections are always good. It is just encouraging to see a number of researchers from within Africa, but as well as from outside Africa. It is the time to call our attention to the part of our wealth and culture which has been suppressed for quite a long time. It is the question of putting such pieces of research work into writing and form a robust literature that will abate our judicial systems. Codification of African customary law is a project worth funding, and it is going to serve its right purpose. I want to stop here, believing that we will continue jointly in this great endeavor and this great cause for the entire humanity. Thank you for watching University of Nairobi School of Law, Kisumu campus. If you have not subscribed, please try to do so. It is good and it will help us to carry on with these debates and intellectual conversations. Thank you for watching. Bye bye for now.